If you've been arrested for a DUI, you might be thinking, how do I appeal or handle this driver's license issue? First, if an officer arrests you for DUI, they have the authority to keep your driver's license and serve you notice through what's called a 1205 form, an administrative license suspension. And at the bottom of that form, it'll say temporary driving permit. Now, from 30 days of the date of the arrest, you have one of two options in fighting or dealing with this potential administrative license suspension. First is through what's called an ALS, administrative license suspension letter. Now, what the letter states is that we are challenging the officer's attempt to suspend the license through civil administrative law. It's totally separate and apart from the DUI case. Now, once we send the letter, about 30 days later, we'll get scheduled for an ALS court date. Now, if you hire our firm, we would send the letter on your behalf and appear at the ALS court date for you. You would not have to attend any of these ALS court dates. At the ALS court date, you've got an administrative judge, there's lawyers, police officers, and people who do not have lawyers. The judge would then call the calendar. They'd call your name, we would announce we're there for you, and then they call for the officer. If that officer fails to appear, then the administrative judge will dismiss this ALS issue, get your driver's license back, and then we can focus exclusively on the case in court. But let's just assume the officer does appear. If that happens, we're going to negotiate with the officer to try to persuade them to dismiss the ALS case, which is sometimes successful. But if that officer is not willing to negotiate, then we're going to reset the ALS court date to give us some time to gather evidence and potentially resolve the underlying case. Because if we do so and resolve it to a non-DUI resolution, that will terminate the pending administrative case. Now finally, let's just assume that the officer is not willing to negotiate and now the ALS judge will no longer continue the ALS case. If that happens, the officer is going to present you with an ultimatum. On the one hand, the officer will say, I'll dismiss this driver's license issue if you promise to plead guilty to the DUI at your next court appearance. Or you can have the hearing that you requested in your ALS letter. And at the hearing, the officer has to testify under oath, and what the judge is considering is whether, by a preponderance of the evidence, number one, it was a valid arrest, meaning the stop was good, the arrest was good, and two, either you agreed to a chemical test of your blood, breath, or urine under the implied consent warning, and the results were a 0.08 or greater, or you had refused such testing. Now, in the case of a refusal, you're looking at a 12-month license suspension. If you agree to chemical testing and the results are 0.08 or greater, it's a 30-day suspension for which you can get a limited permit. If you or a loved one have been charged with the DUI, please, please, please call our office to schedule a free consultation. We can talk about the facts of the case, the law, what has to be proven, the court process, evidence gathering, and how it is we go about fighting these cases.